versus Brandon Jeevers.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Jeevers. Please state your name for the record.
Brandon Jeevers.
Thank you, sir. You're requesting an adjournment now.
We are, Your Honor, for discovery purposes, and I would also ask to briefly address bond.
Probable cause conference in this matter will be adjourned to March 20th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, we are requesting release on tether, a personal bond with a tether. My client, we have information that the complaining witness has left the state. He would like to go back to his home. He's very concerned about losing his home and his car, essentially most of his life in custody for longer. He's involved with this church. He's sober and he understands he has to come to court in the future. So we're asking you to consider release on a tether.
Response.
Your Honor, I would object to any modification of bond. In this case, the victim had been trying to leave the defendant because he had been mentally and verbally abusive. He became upset at the victim, pushed her on the bed, grabbed her neck with both hands, and strangled her. He was holding her down on the bed, and the victim described it as he was staring through her as he was strangling her. Afterwards, she thought she was going to die, and she called the police, but she was afraid he would hear her. So that she then drove to the police department to report the strangulation. She had red marks and scratches on her neck, and she said during the strangulation she began to lose consciousness and couldn't breathe, and remembered the defendant saying he would kill her. So I have very extreme concerns for her safety, even though she might not be in the state because of this event, Your Honor.
Anything else?
We're aware of the allegations in this case. I do think that tether to his residence would protect both the complaining witness and the community in this case.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Of Mr. Douglas, who is seated to my right. Mr. Douglas, could you please state your name for the record?
Clinton Douglas Jr.
Thank you.
Your Honor, my client is asking for his preliminary exam.
Is discovery complete?
Yes, Your Honor.
People have their witnesses available the 18th.
We'll do our best, Your Honor.
Your Honor, if I could address Baron.
Briefly.
Thank you, Your Honor. My client is, as you can see, he's in a wheelchair. He has little to no use of it. Is it your right knee or left knee? His right knee, Your Honor. Right now, they have him in max security because they can't put him on any other floor, I'm being told by my client at least, because he cannot navigate the stairs whatsoever. I understand that my client did not appear for court, Your Honor. In that case, the mailing address was his daughter's, and she told him the day after. My client didn't learn about it till the day after. But he wanted me to let the court know he just had a series of medical appointments because, again, his leg is not usable. And so he was just trying to get all of that taken care of. He has a short knee, and I let him know, and he has to understand that when the court says he has to be here, he has to be here regardless of what's going on with his legs. Your Honor, he's just asking if you would be inclined to either tether him to the house and just allow him to do his medical appointments, but he'll be back when the court requires him to be back. Thank you, Your Honor.
I don't need a response. He knew he had to be here. There's been written, he's been told at various proceedings to be here. And he didn't appear, so I don't understand what the mailing issue is. He was given the date. And certainly he's had counsel who would have also provided the date to him. So that's not a justification for it. I'll set preliminary examination March 18, 2025, 9 a.m. before Judge Barr.
I'm sorry, Your Honor, what was that date again?
March 18th.
3/18. Thank you, Your Honor.
Before Judge Barr. Motion for bond reductions denied. Bond will continue.
Thank you. Alexander on behalf of the people.
Ryan Bowen on behalf of Mr. Johnson. Just state your name for the record. William Johnson.
Thank you.
Your Honor, we're asking for this matter to be set for exam. To my knowledge, all discovery is complete.
People have their witnesses available the 18th.
We'll try our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Barr.
Your Honor, may I address bond?
Sure.
Thanks, Judge. Mr. Johnson is asking to be released. He indicates to me that he can reside with his mother in Charlotte. His mother is here in the courtroom, and she confirmed that today. He also indicates to me that he has a job that is waiting for him, or at least potentially waiting for him at a wastewater treatment plant in the Charlotte area as well. He's 33 years old, has 5 children, none of them with the complaining witness in this case. There'd be no reason for him to have any contact with the complaining witness. He would comply with all the conditions of bond set at his arraignment. So we'd ask the court to consider releasing him on a personal bond with tether of people.
Your Honor, we would be opposed to any modification of bond. In this case, the argument began. The victim was trying to avoid the defendant, and he ended up going outside, coming back inside, beginning to yell and spit in her face. And then had distracted her with an opening to try to get him away from her. He then threw a bottle of hot sauce, a can, and a shelf at the victim. She then went to her daughter's room to get away from the defendant. He then kicked open the door to that room, pushed the victim into a wall, and began to strangle her with both hands around her neck and holding her up against the wall. She had to trip him to get away. He then began kicking and stomping on her ribs, and she started having trouble breathing after that as well. And her daughter had to call 911 to get the assault to stop. So I have great concerns, Your Honor.
Anything additional?
Nothing further, Judge.
Motion for bond reduction is denied. Bond will.
Thank you.
Okay. Hello, sir. What's your name?
Adam Watkins.
Okay. I had issued an order to show cause. You have not been arraigned on this case, and I want to arraign you on the charges or the charge. The citation alleges that on or about January 7, 2025, at the location of Michigan Avenue near US 23 in Pittsfield Township, that you were found in possession of drug paraphernalia contrary to Pittsfield Township ordinances. Do you understand the nature of that charge, sir?
Yes.
That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, please.
All right. This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Watkins. We will waive further readings, standing to the charges, and ask for another pretrial date, please.
And then have a waive formal reading. The court will enter a not guilty plea. Pretrial in this matter will be adjourned to March 19th, 2025, 9 a.m. or as your invite indicates. Set the defendant's bond at a $5,000 personal recognizance bond. I will order. Yes, sir.
I'm going to be in rehab. I got next 10 days. I'm going to be going into rehab for at least 30 days.
When are you going in?
Within the next 10 days. I'm in the process of getting hold of the number to the distribution center.
Okay. Where are you doing this rehab?
This is for Plymouth, Canton Township.
The court?
Yes.
Okay. Do you have paperwork indicating that?
On me, I do not. I just went to court yesterday for it. It's either 30 days in jail.
Here's what I'm going to do. You're going to need to get that paperwork to your attorneys here. Okay. So that they can show the court, but I'm going to leave it set for the 19th.
Within, to bring it up here to the court, I feel like I'll have it within the next couple of days. You know what I'm saying? They're supposed to be sending me the number from Canton for the distribution center. And then I don't know exactly. Okay. To you, right here. Okay, thank you. Yeah.
All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no alcohol, recreational marijuana, or illegal drug use. You understand that, sir?
Yes, Your Honor.
I will also sign an order for community corrections regarding testing. At this point, it'd be 2 times per week, but if you're in treatment, then deal with that. If I were to give you a test today, you gonna come back clean?
Nope.
I didn't think so. What have you been using?
Okay. It's been 3 days or so, but it's still probably come back dirty.
What do you mean it's been 3
I haven't used anything in the past couple of days. But it's still, I don't think it'll come back clean, to answer your question.
Well, your bond on your other case in Plymouth, you're not supposed to be using.
Yeah, this is all right.
Why?
That's why I'm going into rehab.
Are you testing out there?
Not so just starting everything. I just went to court yesterday.
Let me just tell you. Okay. I'm gonna tell you right now, Mr. Allen.
Sentencing.
Young man,
Yes.
I'm gonna ask you this. I'm gonna ask you this once.
Yeah.
When was the last time you used?
It's been about 4 days. To be honest with you. Yeah, the honest answer is I can't give you an exact date, but it's been within 3 to 4 days, Your Honor. To be completely honest with the courts. That's one of the reasons I'm going into rehab. Because of my lack of control.
Where are you going to rehab?
I'm still, I gotta get a hold of their 34th is sending me the number to the distribution center. I haven't gotten it yet. As soon as they get it to me, I'll know exactly then. And I can give the court the information that I have at that point in time.
When did 34th order you to?
No, not 34th, 36th, Plymouth. Yesterday. I was just in court yesterday.
Okay. And they ordered you to rehab.
Yes. Is it 30 days in
What
jail?
judge?
Your Honor,
Goody?
I found the case, if I may.
Yes, go ahead, Mr.
It's before Judge Giroux in 35th. It does look like he appeared yesterday and pled. Their ROAs look a little bit different than ours, so it's a little bit difficult to understand. But it looks like he was sentenced yesterday at noon. It says optional jail term, but that's all I can really see. Optional term 30 days. But it looks like that's all it says really about his sentence.
But it doesn't say anything about treatment.
It doesn't really tell me. Well, it says probation. It's pretty unclear. It says there's a bunch of entries with description. It says crime rights assessment. Oh, those are the fees. Optional jail term, probation, monetary transaction. He paid $125. Scheduled to report to jail 6/20/25. So that may be what he's referring to
Have a
when he
jail?
says,
You got a jail sentence?
If I may, Your Honor, my client seems to be of the understanding that if he were to complete the inpatient rehab, he would not have to do that jail sentence, which I believe that might be why then his report date is in June 2025. If so, maybe that jail time will not actually be imposed if he does that rehab.
right, because it says optional term.
Yes, Your Honor.
I can
Do
print
they
out.
know you? Do they know you've been using?
No. I think that's why I chose to go to rehab versus going to jail. I think rehab would be better for me than going to sitting in jail for 30 days versus going to the rehab. That's what I need. I think
Well,
personally.
I understand that, but that's not my issue right now. Did somebody bring you here?
Yes.
Okay, so, but my question really is, does the other court know that you've been using?
No. To They've not dropped me yet.
Pardon?
They've not dropped me, no, sir, Your Honor.
Did you talk with anybody at the other court, their probation department, anybody?
Yes, I have.
Because I'm going to be honest with you, sir. I think when you give me that 3 to 4 days, I think you've used more recently
No, sir.
by the way that you're acting.
No, I've not used today at all. I've not. I promise, courts, I'm gonna use, it's been at least 3, 4 days. Minimum. I'm a little nervous right now, to be honest with you.
All right. Well, here's what I'm going to do. I'm actually going to set the defendant's bond at a $15,000. I'll just do a 10% bond, but if he's got it, he can pay it. I'll set a special pretrial or at least review of his bond on March 12th, 2025 at 9 a.m. That's my sentencing docket. But that way he's not in your week. Ms. Payton, Ms. Parody, if you get information more specific for me from the other court as to what he's supposed to do, then I'll consider his release. But at this point, he's not leaving here.
Yes, Your Honor.